Hi, today we're talking about 10 things to know about the divorce process and timeline. In terms of the process and timeline of a divorce, here is a typical example of how a divorce can proceed. To start the divorce process and apply for a divorce to dissolve the marriage, you must file and serve, meaning deliver, the writ of summons and statement of claim on your spouse. Your spouse must decide within 8 days if he's going to challenge or contest the divorce based on the terms that you have stated and written in your divorce application papers. The second is that your spouse decides to contest the divorce. He must file 2 documents in court, the Memorandum of Appearance and the defense. The Memorandum of Appearance is meant to acknowledge that he will be participating in the divorce and court process, and the defense is meant to summarize your spouse's key responses to your claims that you have stated and written in your divorce application in this document called the Statement of Claim. Quite often, you and your spouse will then and should discuss and communicate with each other about trying to reach an amicable resolution and settlement before allowing the divorce to go towards a heavily contested and bitterly fought dispute and trial. There will be opportunities to do this through the resolution conference conducted and facilitated by a judge, and also through counseling sessions conducted and facilitated by a court counselor. Next, if you cannot settle your differences and reach a compromise or settlement, the divorce case will move towards a trial where a trial judge in court will assess evidence presented by you and your spouse in support of the respective claims and demands made by you. For example, your claim that the marriage has irretrievably broken down and your spouse's disagreement or denial of this. If your spouse chooses not to challenge or contest your divorce application and only intends to challenge or contest the ancillary matters, your spouse must file the Memorandum of Appearance to point out that the ancillary matters he intends to challenge without filing a defense. Next, if the court confirms and agrees that there is enough evidence to show that the marriage has irretrievably broken down, the court will grant an interim judgment, which is a court order that effectively dissolves the marriage, and the case can then move into the next stage for the court to decide on how to handle the other matters or the ancillary matters. To help the judge and the court properly consider the case and assess how to decide to handle the ancillary matters in a fair way, you and your spouse must file your affidavits of assets and means, and these are sworn statements in which you must clearly state and detail all important information regarding your respective assets and financial responsibilities, such as your salary, your sources of income, and your expenses. You will have an opportunity to respond to and reply to any claims made by your spouse in the affidavits filed by them, and you can give your own clarification and explanation in a reply. If you need to get information from your spouse, which is important, relating to his or her assets and financial responsibilities, in order to simply prepare your own affidavit, then you may be able to apply for the court's help through a process called discovery, to order that your spouse share and disclose the requested information with you. If the total net value of the matrimonial assets that you and your spouse are dealing with is more than $5 million, then your case will be moved to be handled in the High Court. After the filing and exchange of the court papers and affidavits, the court will schedule the case to be heard on a particular date and court session to handle the hearing and the consideration and presentation of the arguments and evidence for the ancillary matters. After the court has assessed the evidence and arrived at a final decision on the issues in the ancillary matters, you and your spouse must wait for 3 months, and this is from the earliest date that the court granted the interim judgment, before you can apply for what is called a final judgment, which effectively formalizes and converts the terms earlier stated in the interim judgment. So, there you have it, some very basic information on the 10 things you need to know about the divorce process and timeline. Thanks for watching.